Bismillah. Bismillah ar-Rahman ar-Rahim. Good morning, everyone. Ladies and gentlemen, I would like to welcome you to this session for the Copyright and Other Legal Matters Committee. Today we have this session entitled Between Rejection and Instruction Generative AI, Copyright and Access to Library Collections. So I'm really glad to lead this session with those really experts from international countries. Let me start to introduce myself first. Jamal Salmi from Oman. I am the director of the main library at the University of Nizwa, and also I am leading or the chair of the Copyright and Other Legal Matter Committee within IFLA. I got my master from the Curtin University of Technology from Australia, and also I got my PhD from the Victoria University of Wellington in New Zealand. So I am still working at the University of Nizwa currently. I have many interests regarding the digital repositories and also sharing knowledge and also e-learning and other related topics. So our session today is about generative AI. So we have two opposite opinions for this topic. On the one side, the copyright industry's strongly negative reaction to the emergence of generative AI, or at least desire to ensure that it takes place under their control, means that libraries are under pressure not to allow any kind of access to their collection for AI training, including for scientific research plans for developing models and tools, in particular in national language or in order to support public AI, have faced attacks in the press and legal threats, often without any basis. The contract offered to libraries are increasingly seeking to limit text and data mining and imposing liability for any mistakes. On the other side, AI companies are pushing hard for access to the same collections, recognizing their unique value in developing new higher value models and service. Not all of these operate openly, making the resulting models available to all. Their practice are all too often give a bad name also to those engaging in generative AI training for public interest ends. Therefore, the session explores the different perspectives, thematic, geographical, and institutional, on the questions libraries are facing when deciding what access to provide to collections for training generative AI. So let's start with a research conducted or a survey conducted by the CLM committee, and they are discussing copyright legislation and AI and what this means for libraries. So I would like to welcome Stephen Weiber for this, and then later also we have the Leslie Street. So please come in.
Good morning, everyone. I might ask if you can change it's the other slides. There we go, maybe, I don't know. So welcome to the warm-up act for the opening session. I can't promise you dancing. The dancing will be better, at least in the next session. Let's let this work through. So I think we're very conscious, I don't know, this isn't even, I don't know, this is the first open session of the conference, and it's not even the first session that's taking place about AI. I was at Yonsei University on Friday, and there was already at least 2 AI sessions taking place within the same building. And so I think we know pretty well that there's, we know pretty well that this is a topic that's being extremely well discussed around the world. It is one, nonetheless, where libraries are increasingly being called upon to take decisions, to make judgments, to pick which side they're on. We are solicited by other actors, by publishers, by rights holders, but also by technology companies that see the value in our positioning, that see the value in our collections and want us to decide. Of course, what we'd say is that we shouldn't be picking a side. We should be a side ourselves. It's not the tech companies, it's not the big publishers that really care about the interests of users. We're the ones that do that. We're the ones that are responsible for that. But of course, in doing so, it's important to be well informed. So what we therefore looked to do through the Advisory Committee on Copyright and Other Legal Matters was to understand things a little bit better, understand what the current legal landscape is as a basis for better informing ourselves, for thinking about how we should react, how we should interact with the legislative landscape. So overall, we sent out a survey. We worked through the CLM, the Advisory Committee on Copyright and Other Legal Matters network, and we got responses from 22 countries, 25 overall. So it's not a huge number, but given that most studies of these things only talk about the US, EU, and China, we're already doing a little bit better than that. So there are a number of countries that responded to the survey, about half, that have actually tried to pass, have actually taken steps in law. These are mainly in the EU. And this, to a large extent, is driven by the Directive on Copyright and the Digital Single Market of 2019, which, of course, brought in provisions around text and data mining. And so there is an explicit exception that allows you to do this, that makes it clear that if there is legal access to content online in your collections, then it's possible to do this. There is a differentiation. There's a slightly broader provision for research institutions than there is for others, but there's quite a fine line within there. There's quite a European attitude towards saying, well, if anything is slightly commercial, we don't really like it. Money's a bit dirty. And so therefore, there's a different rule there that says that if you're a research institution, if it's purely not-for-profit, etc., then it doesn't matter if rights holders say, no, you can't mine. Whereas if it's anyone else, there is that possibility for an opt-out. There is provision to allow storage, so you can keep the data sets, the CSV files that you've kept, in order to carry on, to validate what you're doing, to keep this data for as long as necessary. Again, it's slightly more generous for research institutions, whereas publishers are allowed to implement security measures proportionally. So they can try and stop activities that would crash their systems, but not in a way that would make it impossible for anyone to enjoy these possibilities. Of course, laws that are passed at the European level, when they're directives, can be implemented, transposed quite differently. And so there are different attitudes towards where that line between text and data mining, which is possible without considering opt-outs, where that stops and where opt-outs need to be taken into account. There are different approaches to security measures. Is there reference in national law to the idea that they should be proportional? Can you share results? This isn't included in the directive, but some countries do indeed say, no, you can't just mine, but you can also actually share things more broadly. There's also differences in how text and data mining is defined, the choice of language. In the directive, it says generate findings. In other languages, it's more like identify. So it's not a consistent approach. There are also gaps. What we have in the law, it doesn't say explicitly that you can train AI. However, the general consensus, even from courts whose judgments are seen as being quite negative about this, is that it is there to train AI. AI existed as a technology. There is broader legislation that talks about the transparency of results. Again, there's this fantastically contradictory phrase, a sufficiently detailed summary, because summary and detail don't necessarily go together. So how you define that is not really clear. It's not clear necessarily who's liable for problems. This is something that came out in the survey. And also, there are ongoing questions about, well, what counts? What counts as sufficiently human work to get copyright? But also, what counts as sufficiently close to a pre-existing work to constitute infringement? There's not yet a consistent approach there. Now, not every country has law in place. Legislating is difficult. We have a couple of examples. Canada recently, the UK, where the government tried to think about passing legislation, and it was just so difficult to find consensus. It was impossible even to find a starting point. Finland has a series of committees working on potential AI. They've not even been able to produce position papers as yet. It's a very contentious issue, and normally governments don't want to have to pick their favorite child. They'd much prefer that their children agree first and propose something. There are nonetheless ongoing discussions about a range of issues, about training, about use of materials for retrieval augmented generation, for AI prompts, for issues around the copyright around AI outputs. We also see, interestingly, in China, very much a wait-and-see approach. That is, it's taken some measures to say that generative AI should respect intellectual property, but it hasn't really gone deeper and is taking a much more gentle approach to these things. Of course, there's also been lots of action in the courts. I won't go into that because Leslie will dig into this. But we also see from the survey other issues coming up. So market dilution as an issue, at least in some jurisdictions, we'll come back to that. Efforts to look at deep fakes as a topic, and AI-generated deep fakes, in particular around sexualized content. But also efforts to think about what does a licensing model look like, given that you really can't license the internet. It just doesn't work. In terms of takeaways, but I'm not going to offer you a satisfying conclusion. I'm sorry about that. A key one is that actually legislating is quite hard. It's a very contentious topic. The level of hysteria around AI is high. It is a reality and is not a comfortable place necessarily for lawmakers. And even then, are you sure that with a technology that's moving so quickly, with such a complex issue, with so many implications, with so many repercussions, can you really pass a law that covers everything adequately? Copyright is not the only tool available. And certainly the most successful, the most far-reaching attempts to deal with deep fakes so far have very much drawn on privacy law, on broader criminal law. The Danish attempt to use copyright in order to protect people's faces, it was discussed, it's been broadly dismissed by a lot of countries. We do see from the survey that the debate is not the same everywhere. Market dilution is a big issue in the US, it's a big issue in one or two other countries. In other places, it's not being talked about. So we shouldn't assume that the debate is the same elsewhere. But nonetheless, there's a bit of a choice. We have laws that are unsatisfactory, that don't provide clarity. But at the same time, it's also clear that the absence of laws is also not a source of great clarity. That a lot of the time we had complaints within the survey saying that the failure to provide clarity is creating costs, is creating problems for librarians. So I'm going to hand over now to Leslie to carry on the legal side.
Thank you. So I'm going to talk a little bit more about what happens when, because legislating is so hard, what has resulted in many countries is not legislation, but the courts trying to step in because of arguments brought to the court to resolve disputes under existing copyright laws. So there are a couple of resources I want to point you to that do a pretty good job of summarizing where some of these major cases can be found. There are two maps. The first map is the map of, these are just current disputes going on around the world involving copyright issues and AI companies. And you'll see some repeat offenders in terms of the names of the the names of the technology companies that are being challenged in courts across the world. I'm just going to highlight a couple. This is a really great resource I encourage you to use to follow. Unfortunately, not all of the cases themselves are linked because of access issues, but you can track on this some of the cases. One I'm going to offer as an example. This is a UK case that's currently on appeal. It's an interesting case because basically Getty Images filed suit against Stability AI, concerned that they were using their pictures to train their AI models. And they knew they were using their pictures because in some of the images that were generated by Stability AI, Getty watermarks were appearing. So interestingly enough, the court found that there wasn't secondary copyright infringement because the training itself wasn't enough. They had to prove that there was actually a stored copy of the images. Just using the text data mining, using the materials to train the AI on, the generative AI, that wasn't sufficient. But they did find that there was a trademark infringement because the AI model would generate Getty watermarks. So that's a case that is still on appeal, and that's the other thing that I will point out. A lot of these cases are still in early stages. There can be appealed to higher courts. They're still in their infancy. And so we don't know, even with the cases, where all of these things are ultimately going to shake out. You can see this is just the United States, the number of cases that are active in US courts. There are a lot, and the way that it works in the United States is that all of these cases are filed in different federal courts across the country, and really until the highest court, the Supreme Court, has ruled, we don't know ultimately how it's going to shake out. However, there is one case that I will point out, because this was a district court ruling, so the lowest trial court, that held that scanning books to be used as training data for generative AI was fair use. Now, this is an exception in US copyright law. Other countries, of course, have different standards. There are 4 factors that the courts in the US use to determine whether a use of a copyrighted work is fair. And this one really looked at the transformative use of generative AI, the fact that the AI was using, the companies were using these materials to train AI, which they considered to be a transformative use. However, they did find that there was some infringement, not because of training generative AI, but because the scanned books themselves were saved in a central library that wouldn't necessarily just be used for AI training. And so that they found to be a copyright violation. So there was a settlement that just very recently came out, one of the largest, if not the largest settlement ever, with all of the authors who sued, which was 1.5 billion US dollars. That's a lot. But even that, the settlement, some authors didn't think that that was the right amount. The judge accepted the settlement anyway. So that is a very recent development. Because it is ultimately a settlement, it's unlikely that this case will go any farther, but there are many other cases still pending in US courts. The reason why this matters is even though these cases on their face only apply to the US, the reach of these large, very well-funded technology companies is vast, and it reaches into other countries. This was a recent news article posted in Australia that did some investigative work, and this AI company that they pictured this in is Anthropic. Anthropic is known to try to be the ethical AI company. That's the parent company of Claude. But what they found is Anthropic has a great business where they are buying up rare books from rare book dealers around the world, and then they basically break the book down to scan it and then throw the book away. Which as a librarian, well, that's unsettling, to say the least. But according to US, and a lot of these materials are not covered under copyright protection anyway, because in US law, they're past the date. But you can see the reach affects materials and cultural heritage in other countries. And that's the part that I think really should not sound the alarm for librarians around the world, but help us to realize that we have a role here in considering what the outcome of all of this is going to be. Librarians shepherd and curate cultural heritage, and archivists do all of this. And so we get to decide what we're going to do with our materials. Because, as Stephen mentioned, I don't think that there's going to be a law that's coming in to save us and to determine the reach of all of these things. Ultimately, that's going to be on us to decide how to use our collections and how to protect the materials that we steward. So this is just one example. This is from the University of Virginia, but many other research libraries in the US have signed on to this about how they are going to address working with not just technology companies, but other like research uses for scanning and adopting materials for generative AI training. And the main thing that I want to point out about this, again, I give you a link if you want to learn more. The main takeaways from the statement of shared practice is that they want to make sure that there's transparency and the provenance of materials is clear, because that happens a lot of times. And basically, it's a basic standard that libraries can use to determine how are we going to address this, because copyright law is not going to provide us all the answers. So I'm really excited next to hear from some libraries and librarians who have dealt with this directly with their own collections and learned from them.
Okay, good morning, everyone. I'm Karen Grammel from National Library of Sweden, where I'm a national librarian. And after this overview, I would like to provide you with more of a case study, what we actually have done, training large language models in our library in Sweden. So I will start from there. Okay, just to make sure you know where Sweden is situated, on the other side of the world, I would say. Important in this case is also that Swedish is quite a small language. We can't only use the big international model made from English, so that's why it's important to work with large language models as well in Swedish. Anyway, we start from our library point of view. In National Library, we have a lot of collections, very large collections, historical collections, and collections from everyday life. And our collections, we realized a few years ago that that's the data for today. That's what everyone wants. That's the goal of today. What do we have? We have print radio, we have TV, we have film, we have music. We also have the audiovisual material in the National Library. We have a law of legal deposit since 1661 for a different purpose at that time, but still. And then later on, new legislation for the audiovisual material. We've been doing web harvesting since 1997. We were quite early on that. Unfortunately, the legal deposit law is quite outdated. We only get digital copies if there's no print copy around. Anyway, we do our best to digitize as much as we can. The percent is quite low overall, only 4% of our own collections, but we have huge collections. But for the newspapers, again, which is quite important for the large language models, we have a bigger part that is actually digitized. We also have all the recent newspapers digitized. Our mission is quite important in this case as well. In our instruction from the government, it says we are the National Library of Sweden and a national research infrastructure. So that makes a difference when we go to what we work with in our data lab. So in 2019, we decided to start a data lab at the National Library. We could see a need from the researchers to use new models, to work with large-scale analyzers, and to work with digital humanities, etc. We also could see a need inside to rationalize our work with collections. You know, a lot about cataloging, metadata, but also how we can give more efficient access to our very large collections. I won't talk about that part. That would be another presentation. I will talk about the research part. The time caught up really quickly, and the boom of AI came up. And that's why we realized that we have all this fantastic data to work with LLMs. We work mainly with predictive and descriptive models. That means we don't focus on generative AI for several reasons that I can go into later. Anyway, the predictive models are more like probability, what is the next word in natural language, and the descriptive models are used for analyzing text, I would say. Well, you need collections, you need clever people, you need a lot of competence, and you need computer power. And luckily, we have been able to use the Euro HPC, the high performance computing in EU. You have to apply, it's a research application, but we've been able to use that, and that's made it all possible. We put our models out in the open on GitHub, and they're very, very highly downloaded. We don't make any services, etc., but we put the models out there, and they've been spread out with no marketing. They've just been used a lot. And important again is that the TDM, we think it's natural use TDM for AI, is conducted only on site. So all protected copyrighted data stay in-house, because we don't think we have a permission from the law to actually let the data out. We can just use it in our own institution. So what is the potential for National Library from the Middle Ages to actually work with AI? Well, there are quite a few, that's quite a lot. And in 2025, almost a year ago, the government decided to strengthen our mandate and increase our funding for working with AI. That was part of a big part of the budget process last year, actually, to put more money into AI production as a whole, and we were a small part of that. First, we do have the mandate to be an infrastructure for research. And of course, we have high-quality Swedish language data. No one else, I would say, has the same amount of high-quality data in Swedish that we have. And we know our collections. You know, before you can actually start to work with the data, there's a lot of washing and preparing of the data. And we have people who know the provenance, we have people who know where it comes from, the metadata, etc. So I would say really to combine that sort of curator competence with the data scientist has been a success, really. And then again, the data represents all types of language and expressions, from local radio to more strict formal papers, etc. Again, the lab is trusted to use the Euro HPC. And also, we did a report actually this springtime, and we can see that we can provide a transparency for public sector in AI tools. If you're using AI for making decisions, for example, in authorities, you have to be able to have transparency. What models did you use? How does that model work, etc. And we can see that we can provide that. To be more concrete, I'll say something about the KB. KB, that's a Kungliga biblioteket, that's the name of our library. Whisper, that's a special model that we launched, I think, a bit more than a year ago, and it's a speech-to-text model. It's based on the OpenAI speech-to-text Whisper model, and then it's been trained and fine-tuned on many hours, 50,000 hours of Swedish speech. And one important part is actually the parliamentary debates, because in the parliament, in the chamber, all debates are recorded and transcribed. So you have the writings, and you have the actually recorded sound. So that's a wonderful data to work with, and that's open data, so not copyrighted protected. So that's been a very good cooperation, and then I used the model actually to transcribe the debates in the parliament. So that's a rationalization for them. So I would say, because I have very clever people working with this, it's been a big success, because it understands Swedish expressions, Swedish special, allusions, etc. It's very specified for the Swedish language and also for the Swedish context. Okay, then about copyright. And Stephen just told you everything I would say about the DSM, the Digital Single Market Directive. That's the basis for our copyright legislation in Sweden as well. And we have the Article 3, text and data mining for the purpose of scientific research, and that's what we line very heavily on in our work in the library. And it's very strong. It said that the member states shall provide, there's no option really, for an exception for reproduction and extractions, that we can make copies made by research organizations and cultural heritage institutions in order to carry out for the purpose of scientific research, text and data, mining of works, and other subject matters to which they have lawful access. And this is, of course, implemented in the Swedish Copyright Act a few years ago. And what is also important is that contractual terms that restrict the right to use works under these sections, they are invalid. So you're not actually allowed to put a license that says that you have to pay for the data, because this is compulsory as an exception. So, do we fit under this exception? Yes, we think we do. We have 3 very major requirements that we have to fulfill. We have to be cultural heritage institutions. I would say that's pretty clear if we are. We need lawful access, and it's quite clear that either you buy the material or you have some legal access to it, and the legal deposit law is certainly legal access for that. And you have to do the TDM for purpose of scientific research. And then again, in this context in the EU, the work aimed to generate new, verifiable knowledge in ways that ensure independence. And also, what is important is that the result shall not be exclusively benefit individual interests. It should not be made to license for a certain company, etc. It should be made openly to make further research possible. So we think we fit into all that, and to make sure, well, there are different opinions, of course. We had some external assessment this springtime as well. We asked 2 very prominent copyright researchers that been around for a long time. Do you agree with our interpretation? And they did a report on this. It's in Swedish, but it's available on our website. And they fully support our interpretation of the law, which put a relief, of course, for us. But of course, again, Leslie was talking about all the court cases going on, and ultimately this is a matter of the courts to determine if this is the way to go. But we haven't seen that yet as clear. Okay, is everyone happy with this? I would say no, everyone is not happy with this. The copyright holders have been really upset, and there's been a lot of debate in the Swedish newspaper and Swedish media, for example. The copyright holders all own the media, so that makes it quite clear as well. These are two articles from 2 leading Swedish newspapers. I try to, I put it in English here. Petition against the National Library of Sweden, AI model development, copyright is being bypassed. That's how they put it. And the other one from another big newspaper is, does the government understand that it's enabling piracy? For the second one, we were quite upset, and we did write an answer. Otherwise, we're trying to be quite low-key in this and sort of just carry on, do what we do, and not get too upset. But of course, there are different interests here. Interests from the creators, of course. They're worried for the future, for generative AI more than what we do. And for the newspaper owners, they want to sell the data, to earn money from that. Publishers, they also want to use AI to rationalize and also to earn money from it. So they're all different interests, and they are more on a political level, I would say, this discussion really. Okay, so that was our case. I would say that we found ourselves as an historical institution in the middle of the AI debate in Sweden, quite unexpectedly, I would say. So, thank you.
Thank you, Karin, from the National Library of Sweden. So she gave us an overview from the European perspective. And also we have another two international speakers from US and also from Japan. So unfortunately, both of them, they couldn't attend to the conference because of the medical and other issues. So they are apologizing for this, but they sent us their videos. So the first one will start with the Kylie Courtney. She is from the University of Mary, Washington, Simon College of, she got her master from the Simon College. Kylie is Executive Director of the Social Law Library in Boston at Northeastern Law. He teaches in the areas of cyber law, privacy, and legal writing. A nationally recognized expert in copyright and information policy with extensive experience at the intersection of law, libraries, and education. He previously served as Director of Copyright and Information Policy for the Harvard Library, where he provided strategic leadership on intellectual property, licensing, privacy, and digital access rights for Harvard University. Professor Courtney is widely published and is frequently sought after as a speaker on topics such as copyright, fair use, licensing reform, and the legal challenges of emerging technologies. So let's see. Yeah.
Hello, everyone, and thank you for having me. I want to start by extending my deepest gratitude to the IFLA organizers and all of you attending today. I'm incredibly sorry that I could not be there in person with you to share the energy of this conference, but I'm honored to be able to join you by video to discuss a topic that is fundamentally reshaping our profession. And obviously today we're talking about AI. And we're also going to talk about copyright and access to our collections. Specifically, we're going to dive into about how libraries across the globe find themselves caught in a vice between two intensely opposing forces, right? Rejection on one side and, if you will, extraction on the other. Just great rejection. So following the explosive emergence of generative AI, the copyright industries, and again, the publishers, the rights holders, and the creators, have had a strongly, I guess I would say, negative reaction. We've seen a wave of panic sometimes, and because of that panic, libraries are under immense pressure to lock down their collections at times, or at least they're thinking of making these decisions. And we're seeing rights holders demand that, you know, if you're going to acquire my materials, you prohibit any kind of access to the materials for AI training. Now, this blanket rejection doesn't differentiate between commercial exploitation and genuine public interest research and plans to develop AI models for scientific research or models trained in national language for their local culture, tools designed specifically to support public AI are facing severe backlash. We're seeing legal threats and attacks in the press leveled against projects that are perceived of as too broad or that are utilizing too much material without paying compensation. And some of these are often made without any solid legal basis. The default answer from those that are kind of policing the copyright industry has become an absolute no, right? No training whatsoever. But then we have this second force going on at the same time, which I define as extraction, right? This is the other side of the vice, so to speak. Commercial AI companies are pushing relentlessly for access to those exact same library collections, right? They have certainly scraped the open web. They have realized that the internet is full of things that you may not want to train an AI system on, right? They now recognize the unique, high-quality, curated value of library collections. And they need our data to develop new, higher value models and services. The problem is that not all of these companies operate transparency in the same way many libraries do. Certainly, they extract the data, train their models behind closed doors, and lock the resulting tools behind, paywalls sometimes, failing to make the benefits available to all. And I think this kind of aggressive, opaque extraction gives a bad name to the entire field, right? We don't want to poison the well for those that are genuinely trying to engage in generative AI training for public interest, research, and educational ends. So here are the libraries. We're stuck in the middle, right? How do we navigate this? And to answer that, we have to look closely at the legal landscape. I'm going to look at the United States. So let's start with the United States. In the US, we do not have a specific statutory exception in our copyright law for text or data mining or AI training. Instead, everything hinges on the doctrine of fair use. AI companies have broadly argued that ingesting copyrighted works to train an AI model is a transformative fair use because the machine isn't reproducing the books or articles to compete with them. It is extracting patterns, concepts, and statistical relationships, right? However, rights holders are fighting back fiercely, right? The legal battleground in the US right now is highly fact-specific and centers heavily on market harm. In recent rulings like Thomson Reuters versus Ross Intelligence, the courts have shown a willingness, I guess, to side with rights holders when an AI tool directly competes with the original creator's market. And we're watching other massive ongoing litigation, right? New York Times and OpenAI and other ones in which will, I guess, ultimately test the boundaries of whether AI training is inherently transformative or it acts as a market substitute. But for libraries, there's a secondary legal layer that's arguably much more dangerous than the fair use debate itself, and that's contract law, right? So time and time again, we see standard corporate boilerplate language in vendor database renewals and licensing agreements that strictly prohibits any form of text and data mining. Now, these contracts are designed to override our statutory library exceptions that we have. So even if AI training is ultimately deemed a fair use in the US, and it has been by a few courts, subject to some interpretation, a restrictive contract can preempt that. And that could strip libraries of their ability to support computational research, and that, I believe, is problematic. So all of these developments raise a serious critical implications for libraries and their patrons, right? So what might those be? Well, on one hand, we offer exciting opportunities. I don't want to say this is all dead. I am as excited by the potential for AI as anyone else, as long as it's done well. They can support more efficient research. They can improve accessibility, especially for users with disabilities, and enhance user engagement through natural language interfaces, which is always important. On the other hand, as I've pointed out, I think you're gathering this, libraries must tread carefully. Many generative AI tools do not make it clear what content was used to train them or how they treat user inputs. And this lack of transparency can lead to inadvertent copyright issues, even privacy breaches we've seen threats of, especially when patrons or staff use these tools to process proprietary information, right? Libraries have a responsibility to uphold ethical standards, certainly, but particularly around equitable access and international intellectual freedom. It's essential that we approach AI adoption with policies that reflect our values and protect our communities. So knowing this landscape, what are the pitfalls we must avoid? In my experience, when we're receiving or navigating requests for a request for data access, one of the first pitfalls is what I call contractual surrender, which I alluded to. When we renew database subscriptions or acquire new digital collections, vendors are aggressively inserting anti-AI and anti-TDM clauses into the terms of service. And if a library blindly signs these agreements, we're voluntarily contracting away the rights of our patrons and researchers. We lose the protection of fair use in the US and potentially even undermine scientific research exceptions in the EU. Pitfall number 2, however, which I've called the vampire deal, is what happens when a commercial AI company approaches a library offering digitization services, money, or software access in exchange for, raw access to our unique collections. The pitfall is handing over our culturally, historically significant data without securing any public good in return, right? If a commercial entity mines our collections to build a proprietary model that our own patrons eventually have to pay to use, I think we failed in our mission, right? We have enabled extraction without reciprocity or remuneration or something that would, serve the mission of promoting progress science in this field. And then last is you're too nervous, right? By fear, you're paralyzed, if you will. So reacting to the copyright industry's panic by completely shutting down all computational access to our collections would not be good. If we do that, we abandon our roles as engines of research, right? We allow the fear of commercial extraction to kill nonprofit, academic, and public access to AI development, and we should not do that. And we don't just have to play defense against all these pitfalls. We can build our own ethical and infrastructure. And I know this because I've seen it work. Before my current role as executive director at the Social Law Library, I spent 15 years at Harvard Library serving as director of copyright and information policy, and I helped plan the HLPDC. It's one of the last things I did before I left Harvard last year. And this is kind of interesting. During my time there, we looked at the legacy of Harvard's Google Books project, which was from the early 2000s, where nearly 1 million books in Harvard's collections had been scanned. And we realized we had a massive opportunity to take the works, especially the ones that were firmly in the public domain, and turn that legal principle into a lived reality, right? So once the agreement was defunct and the project was defunct, we were capable of releasing those public domain works. And we did a soft launch, right? It's a data set of nearly 1 million books, spanning more than 6 centuries, transformed into structured, research-ready, machine-readable data. And instead of locking behind a paywall, we released it, right? We did this because we thought that the AI training landscape might be relying too heavily on proprietary, opaque, and, with the Books 3 example, ethically or legally questionable sources. So libraries can fit in this space by releasing a documented, open source, legally sound data set. We shifted the control of training data away from the tech companies and give it back to the public, right? Smaller players, academics, researchers have a fair chance to compete in building the next generation of AI without fear of hidden costs or legal uncertainty. Access. How do we find our balance between that rejection and extraction? First, I think we must negotiate more aggressively. We have to reject standard corporate boilerplate that bans all automated analysis, right? So if we're negotiating a digital license, I think we should insist on carving out clear terms that protect text and data mining for non-commercial, academic, and public industry research. Under EU, you have that as an exception, right? In the US, I think we have to write that down clearly since we don't have fair use law as targeted towards this, except for a few cases here and there. Our statutory rights are only as strong as the contracts we refuse to sign away. Second, I think we have to leverage our unique value of our collections and demand transparency and open access, right? If a commercial AI developer wants to access your large archives or your collection, right, dictate the terms to them. We should require that the resulting models be, available for public research or for our patrons or our community, that the trading data benefits the broader open source or open access community, right? We hold the high quality data they desperately need. We should not give it away so cheaply, I think. Finally, we must clearly distinguish between public interest and commercial exploitation. Libraries should be vocal advocates for models that support national languages, cultural heritage, and open science. We need to educate our stakeholders, and sometimes the press, that not all AI training is theft, right, quote unquote. When conducted responsibly, transparency, and legally, AI access, computational access, machine learning access, TDM, whatever you want to call it, to library collections is the next logical evolution of reading and research. So I'd like to close out and just say, look, our mission has not changed. The libraries have always been the guardian of knowledge and research. The only method that has changed is what reading and access looks like today. So I think there's an absolute middle path here that respects creators, certainly, and ensures the next generation of AI is trained on our collections, which we have been doing for centuries. The wealth of human knowledge that is preserved there, I think, is incredibly important. And so those are my thoughts.
Thank you for Kylie. And now we come to the last speaker, Professor Vino Titatsu Hino, Professor of Law at Wasio University, Director of Research Center for the Legal System of Intellectual Property, also Director Institute of Comparative Law, Wasio University. So let's see the video.
Can we put on the final video?
Hello everyone, my name is Tatsuhiro Ueno from Japan. It's a great pleasure to be able to talk to you today. Thank you very much for inviting me. So let me briefly introduce myself first. I am an IP professor and mainly in the field of copyright law. At the same time, I'm the president of a collecting society of the remuneration for the online transmission of libraries collection called SOLID. So I'm going to talk about AI and copyright, focusing on the TDM, copyright exception. TDM is text and data mining. So with regard to library collection. So as you know, text and data mining, TDM, is the process of deriving new knowledge from text and data. TDM brings us enormous social benefits. And libraries can contribute greatly to TDM activities because of the vast amount of material they hold. So analyzing such materials gives us a wide range of new knowledge, which makes it possible to develop a system such as automatic translations or large language model and so on. So in fact, several national libraries in the world provide digital collections for researchers. So I was once invited to the National Library of Sweden, which has a data lab called KB that provides a digital collection for researchers to develop high-quality Swedish AI model. Also in Japan, the National Diet Library has a program to make the OCR data of the library collections widely available for the use of TDM. Based on the Japanese TDM exceptions, this is apparently legal. However, the dramatic development of generative AI technology has caused great concern among publishers in Japan. So actually, around May in 2024, the website was redesigned, and this message about the TDM service, the words, suddenly disappeared. This was unfortunate for me. So anyway, TDM brings us enormous social benefits. However, TDM basically involves the reproductions of copyrighted works, so which requires the authorization of copyright holders in principle. Therefore, an explicit provision on copyright exception for text and data mining is very much helpful. So that's why TDM exception is currently one of the most important issues in the field of copyright law. So let's move on to the next section. So TDM copyright exceptions can be seen in several jurisdictions. If you look at this slide, you can find that Japan is the first country in the world to introduce a TDM exception. So since then, some other jurisdictions have introduced the TDM exception, but there are differences between jurisdictions. So this is the Japanese TDM exception, but I can say that the Japanese TDM exception is basically broad. So let me point out some features of Japanese TDM exceptions. So especially we have no opt-out mechanism. So the right holders cannot opt out from the use of the copyrighted works under the Japanese law. So therefore, when you conduct TDM activities, you don't need to check whether the copyright holders have opted out or not. So this is the difference between the jurisdictions. So this slide shows the differences between jurisdictions. It is a little complicated, but I can say the Japanese TDM exception is basically the broadest one in the world. We have no opt-out mechanisms, so and lawful access requirements. So I have no time to go into detail today, but so the Japanese TDM exception is very broad and permissive. So that's why I usually say that Japan is a machine learning paradise. So let me conclude by briefly summarizing my talk and emphasizing the importance of contract. So TDM brings us enormous social benefits. Therefore, the TDM copyright exception is valuable to promote TDM activities. And libraries can contribute greatly to TDM activities because they hold a vast amount of materials. And analyzing this material provides us with a wealth of new knowledge, enabling the development of AI systems in each language environment. So, but on the other hand, the dramatic development of generative AI technology has caused great concern. However, let me touch upon the importance of the contract. So regardless of whether or existence of scope of the TDM exception, it would be possible and valuable for AI developers and also right holders to enter into a contract. So regarding the use of large amount of data for AI training. So I believe that it would be valuable to establish a win-win relationship between AI developers and right holders. In my opinion, whether this contract is a copyright-based license or not is irrelevant. I hope that such win-win relationship will be furthermore developed in the field of copyright, in the field of AI and library collection. Thank you very much for your attention.
Thank you very much for all the speakers. I think we are running out of time, so we have only 2 minutes remaining, so we can receive 1 question or 2 questions, please, if you have any question for those speakers. No question? I think it's a debatable issue, so we can conclude this session for today because we can also leave the stage for the launch of the WLIC Congress after half an hour. So thank you very much for attending and wish you all the best.